of TCC Judgment 111 Champagne Night 2022 Case on the competence to dismiss civil servants graded D in performance evaluations. High notes. In this judgment, the Taiwan Constitutional Court TCC upheld the constitutionality of Article 6, Paragraph 3, Subparagraph 4, Article 7, Paragraph 1, Subparagraph 4, and the Article 8 of the Civil Service Performance Evaluation Act. By elaborating on the distinction between the legal institution of discipline and the punishment of civil servants, the TCC ruled that the provision authorizing the administrative agencies to dismiss civil servants based on their performance evaluation are in accordance with the constitutional principle of separation of powers and not in violation of people's right to hold public office. Background note. The petitioner is the fifth panel of the Taipei High Administrative Court in hearing the case concerning the dismissal of a civil servant. The petitioner believes that the pertaining Article 6, Paragraph 3, Subparagraph 4, Article 7, Paragraph 1, Subparagraph 4, Article 8 of the Civil Service Performance Evaluation Act, and Article 3, Paragraph 3, Subparagraph 7 of the Administrative Procedure Act are in violation of Articles 18 and 17(7) of the Constitution. Article 77 of the Constitution confers that the judicial yuan with the competence to decide on disciplinary measures against civil servants. However, the disputed provision have granted the executive branch the competence of punishing civil servants based on their performance. The petitioner therefore suspended the trial proceedings and lodged a petition for constitutional review in June 2020. Summary of judgment holding. Article 6, Paragraph 3, Subparagraph 4 of the Civil Service Performance Evaluation Act, hereinafter the disputed Provision 1 and the CSPEA, stipulates that unless otherwise stipulated in this Act, evaluations subject to whom none of the following conditions apply during the year under evaluation shall not receive a grade of D. 4. Persons guilty of conduct unbecoming or who violate related legal prohibition causing serious harm to the reputation of a civil servant for whom tangible evidence exists. Article 7, Paragraph 1, Subparagraph 4 of the CSPEA, hereinafter the disputed Provision 2, stipulates that annual performance rating rewards and penalties shall be administered in accordance with the following provision. 4. Grade D, dismissal from employment. Article 8 of the CSPEA, hereinafter the disputed Provision 3, stipulates that concerning rewards and punishment for additional performance rating, persons rated Grade D are dismissed from employment. The stated provision conform to Article 18 and 77 of the Constitution, in which the former guarantees the right to hold public office, and the latter stipulates that the judicial yuan shall be the highest of judicial organ of the state and shall have charge over cases concerning disciplinary measures against civil servants. Recently, the disputed Provision 1, 2, and 3, which empower the administrative agencies or executive authority to dismiss civil servants with a D grade in their performance evaluation, are not in conflict with Article 77 of the Constitution. A. Empowering the administrative agency to dismiss civil servants is in accordance with the principle of separation of power under the Constitution. An administrative authority cannot function without the power of supervision over its personnel, as it is the indispensable core competence of the executive yuan power. In our legal system, a dismissal generally refers to the termination of an individual civil servant's current position, including dismissal due to punishment or disciplinary action, dismissal due to other reasons, or resignation. After dismissal, the chief executive no longer has the power to supervise individual civil servants. In other words, the competence over personnel starts with the appointment of civil servants and ends with their dismissal. Both are quintessential personnel matters. Based on the doctrine of the unitary executive, or the principle of administrative unity, and the principle of responsible government, or the principle of responsibility in government, the chief executive must have certain authority over the civil servants in order to carry out tasks and achieve administrative objectives. Although the law provides general provision regarding the qualification, procedures, and effects of the appointment and dismissal of civil servants, it cannot completely deprive an administrative agency of the power of appointment and dismissal. Otherwise, it will infringe upon the core personnel power of the administrative agency. In terms of carrying out government policies, the cooperation between superiors and subordinates, and ensuring the principle of the unity of executive power, the competence of dismissal of civil servants is even more important than the competence of appointment, especially for posts in the civil service that have qualification requirements. The employing agency may not be unable to choose the most suitable freely. Still, if the employing agency cannot legally remove unsuitable civil servant on the account of poor performance, illegal activity, or incompetence, it will inevitably affect administrative efficiency and even hinder the achievement of administrative objectives. Compared with the power of appointment, the competence of dismissal is more effective in exercising direction and supervision. It is an inherent and core executive power that cannot be deprived. The annual performance evaluation for civil servants, established through the disputed provision, are a major part of the administrative agency's personal authority. In particular, routine evaluation, including annual evaluation, are necessary mechanisms for administrative agency to commend, supervise, and remove unsuitable civil servants. Since routine evaluations are based on a comprehensive assessment of civil servants' performance through the year, and considering that the supervising officers and the chief executive usually have the best understanding of the operational needs of the agency and the work, conduct, knowledge, capability, and performance of each civil servant. The administrative department should be the most suitable decision-making agency and the more appropriate for making the initial judgment, either organizational-wise or procedural-wise. Compared with the executive yuan, a branch that supervises the personnel. Although the court has legal expertise, it may not be as familiar with the implementation of various administrative tasks as administrative agencies do. Moreover, the primary function of the court is to provide external ex post facto remedy, which is limited to the review of legality instead of review of appropriateness or whether the action achieves its purpose. Therefore, whether an organizational-wise, procedural-wise, or professional ability-wise administrative agency should at least be the main agency for exercising the competence of dismissal. It is factually difficult and inappropriate for the court to completely replace the administrative agencies and become the first decision-making body for dismissal based on performance evaluation. To conclude, in the spirit of constitutional interpretation, it should be recognized that and guaranteed that the administrative agency have the competence to evaluate and dismiss their personnel based on reasons specified by law and under significant circumstances, including incompetence, serious hindrance to the effective execution of public duties or other serious misconducts through due process of law. It would contradict the principle of functional organizational structure, which suggests a functional allocation of power for the competent authority to achieve its objective, and violate the principle of separation of power under the Constitution if the administrative agency are deprived of the competence to dismiss the civil servant entirely. Although the power to dismiss is a core competence of the executive branch, it is not unlimited. To improve the civil service and protect the right to hold public office, the legislature may enact laws to stipulate the ground for dismissal and the required legitimate legal procedures. The dismissed civil servant may also request judicial remedy in accordance with the law to check administrative discretion. However, such legislative restriction must not completely strip the administrative agency of its competence of dismissal or transfer such competence to other agencies, otherwise it will infringe upon the core of the executive power, undermine the principle of reasonable, responsible government, and lead to imbalance of check and balance. B. Empowering the administration to dismiss civil servants is not in conflict with Article 77 of the Constitution. In accordance with the current regulation, the calls for discipline and punishment often overlap, but their purpose and effects are different. In terms of effect, the current Civil Service Disciplinary Act stipulated that dismissal not only relieves civil servants from their current position, but also has the effect of prohibiting them from being re-employed as a civil servant. The CSDA also stipulated that the revocation of employment not only revoke their current position, but also has the effect of suspending their employment for a certain period. On the other hand, the dismissal stipulated in CSPEA only has the effect of dismissing the person from their current position without fundamentally deprive them of their civil servant qualification. Both the legal institution for discipline and the punishment of a civil servant can be traced back to the period of political tutelage of the Republic of China. They are inherently different systems and have been implemented continuously in a parallel manner after the implementation of the Constitution. Both the original meaning of the Constitution and the provision from the constitutional amendment do not stay, where Article 77 of the Constitution implies the principle of unification of disciplinary measures, which means only the judicial branch possesses the competence of disciplinary, nor do they prohibit administrative agency from exercising the power of administrative punishment with the effect of dismissal. The past J1 interpretation also acknowledges that both the executive and judicial branches may make decisions that result in dismissal or similar effects. Article 77 of the Constitution stipulates that the judicial yuan shall be the highest of judicial organ of the state and shall have charge of civil, criminal, and administrative cases over cases concerning disciplinary measures against the public functionaries. However, in view of historical references to the drafting of the Constitution, the National Constituent Assembly at the time of establishing this provision to avoid the control yuan proposing and adjudicating impeachment case simultaneously. Therefore, the competence to discipline civil servant after an impeachment case was brought against him or her has been transferred from the control yuan to judicial yuan. The Constitution clearly designated in Article 77 that disciplinary measures against civil servants as the responsibility of judicial yuan. The intent in this article is only to use judicial discipline as an external check and balance mechanism on the control yuan's impeachment power, and to prevent the control yuan from playing the dual role of the player and the referee in an impeachment case. It has nothing to do with parallel system of administrative punishment of a civil servant. In other words, the disciplinary measures against the public functionaries, as stipulated in Article 77 of the Constitution, shall not be interpreted to include administrative punishment pursuant to performance rating, nor is the court required to serve as the first decision-making body for punishment and disciplinary disciplinary measures against the civil servant. 2. The disputed provision do not contradict the right to hold public office enshrined in Article 18 of the Constitution. The dismissal of unsuitable civil servant under the disputed provisions is to implement the doctrine of unitary executive or the principle of administrative unity and enhance administrative efficiency, which can be seen as compelling public interest. Moreover, under the systemic interpretation, the pertaining administrative agency may only dismiss the civil servant with grade D performance rating when he or she meets the requirement of guilty of conduct unbecoming or violate the related legal prohibition or causing serious harm to the reputation of a civil servant for whom tangible evidence exists under the disputed provision 1 or under subparagraph 1, 2, and 3 of the same provision. The restrictions imposed by the disputed provision are substantially related to their purposes, hence not in violation of the right to hold public office enshrined in Article 18 of the Constitution.